NACDL is the association of the nation's criminal defense bar.
In 2009, myself and my young associate, we were trying a murder case where our client, a young African-American male, was accused of shooting another young African-American male in the leg. And of course, after he's shot in the leg, he develops a pulmonary embolism and dies, and our client gets charged with murder. And when he comes in, he says, "Mr. Davis, I didn't shoot him, and if I did, I didn't cause him to die." And so we were set for trial. And we went to trial, and of course, in 2009, this is right after Obama's election as president, and a lot of African Americans and a lot of people in general are really involved in the political process. So our jury veneer comes in, and we have one of the most diverse jury veneers we've ever seen. We have at least 20 African Americans on the veneer, and we know we're going to get maybe even 6 African Americans on the jury once we go through jury selection. So the state starts their jury selection, and they, of course, eliminate a couple of people with challenges for cause, but we still have a bunch of people who are viable. And then we do our voir dire, and we eliminate a few people with challenges for cause, and then it comes time for us all to do our strikes. We sit down and we do our strike, and the client's feeling really confident, and we're feeling really confident as well, because we know we're going to get a diverse jury. And we sit down, we turn in our strike sheet, and the prosecutor turns in their strike sheets. Both sides have exercised all of their peremptory challenges. After all of the challenges for cause, in the strike zone, in the area where we would have juries, of that 32, we had 8 people who were African Americans, 8 African Americans at least. We thought we'd at least get 3 or 4. And when we sat down and we heard the names being called for the people who were filing into the jury box and who were going to be on a jury, our client's mouth fell open. And I felt a chill come over me, because the state had used, and in Texas we all get 10 peremptory challenges, the state had used 80% of their peremptory challenges to eliminate 100% of the African Americans on a jury. So immediately we jump up and we run up to the bench and we say, "Your Honor, we object. This violates Batson," and we make a Batson challenge. And before we even start, the judge is nodding her head yes. A prosecutor-oriented judge is nodding her head yes, and she grants our Batson challenge. And the funny thing is that, instead of seating the jurors, she reset our trial for three months. And so the client's sitting in jail for an extra 3 months, but we're thinking, well, we'll go back and we'll get a fair jury. And the thing was just shocking. It sent shockwaves through the courthouse. And same thing with Obama coming into the office. We had a new DA who would come into the office, and she had never been a prosecutor before. She had never done defense work before. She had only been like a magistrate judge, but she was elected DA on the change, and it shocked her, so much so that she disciplined both of the prosecutors, and it made the front page of the Houston Chronicle. Now, it didn't make the front page of the Chronicle. Well, you're applauding, but it didn't make the front page of the Chronicle because of what they did, I think. I think it only made the front page of the Chronicle because she disciplined them, because it was such a rare move by a DA. Someone who didn't know, she was shocked by the discrimination of it all, and she disciplined them. So 3 months go by, and we get ready to try this case again, and we get a new prosecutor, because when they get disciplined, she actually demoted them. One guy was a chief, she demoted him. Another guy was a trial lawyer, she moved him to a different bureau. She docked their pay, she really took a hard stance. So lawyers in the office were taking note. We would think that things had changed, but we get ready to try this case again, this murder case again in 2009, 3 months later, and we pick a jury. Same thing happens again, in the sense of we have an incredibly diverse panel. We know we're going to get African Americans, maybe half of the panel being African Americans. The second time we try it, we have 8 jurors, again, who are in the strike jury, who are African American, that are in the strike zone after our challenges for cause have been exercised. And again, the state uses 80% of their strikes to eliminate 100% of the African Americans on the panel. And all white jury is about to be seated, and we approach and again make a Batson challenge, and we again argue, and this time Maybe because, the prosecutor was aware of what would happen, or maybe because the judge was worried about this prosecutor being disciplined, our objections overruled. And we proceed to trial with an all-white jury. And this is something that's kind of interesting in America, I think. I think we have cases, right? We see celebrity cases, and they're the cases that people think are difficult to get convictions on. They're the cases that people think are tough to prosecute. We know about O.J. and Bill Cosby, which are two such cases. Now, they have something in common. O.J. was accused of killing 2 Caucasian victims. He had a cross-racial crime, and so was Bill Cosby. He was accused of raping a woman who was Caucasian. But the differences was there, right? There's some difference. O.J., we know, he went to trial, and he was found not guilty. He was acquitted here in California. Whereas Bill Cosby just recently went to trial, and he was convicted of every count. So one wonders, what's the difference in these cases? And I think just about anyone, not everybody, but just about anyone could figure out what the difference is. Just about anyone aware could figure out the differences in those cases, because O.J. Simpson went to trial with one of the most diverse juries in the history of America. Whereas Bill Cosby, in both of his trials, had predominantly white juries. He had juries that had maybe one African American, and Batson issues were raised in both of those cases. And I think the issue of race and voir dire is point and center for a defense lawyer, because ultimately America's history has been one of racism and has been a history that's a racial history. After the World War II, soldiers returned home and had issues with housing discrimination. There were redlining districts, there were places they couldn't get loans, and still African Americans have a difficult time because the government institutionalized racism in lending through the FHA. And in addition to that, policing has always been an issue. Policing has always been an issue in minority communities. There have been protests even way back when in the days. And those aren't the only places they've been issues.
In the Emmett Till murder trial, the all-white jury has acquitted the 2 white defendants accused of killing the 14-year-old Negro youth. The jury foreman said the deciding factor was the state's failure to prove the identity of the body pulled from a river near Sumner, Mississippi.
A juror later revealed that the jury had stalled to make it look good. They wouldn't have taken so long to return to the courtroom, he said, if they hadn't stopped to drink pop.
The verdict came in not guilty. You could hear guns firing. I mean, it was almost like a 4th of July celebration, or it was almost as if the White Sox had won the pennant in the city of Chicago.
Most of us remember the story of Emmett Till because of what May Till did by leaving that casket open. His story made national news and international news because of her bravery and her courage. So I wanted to honor her by including her in this presentation. But I also wanted to note that the people who were accused of killing Emmett Till were acquitted by an all-white jury. America's history is stemmed with situations where all-white juries have played a role in the criminal justice system. I mean, some of you may know about the 1855 trial of Cecilia Slade, right? She was a slave girl who, like Emmett Till, was 14 years old when she was purchased by her slave master for the sole purpose of having sex with her. So when she's 14, she gets on a plantation. The very first night, he rapes her. And then he rapes her continually on the plantation for years. And one night she grows a little tired. And when he comes in to rape her, she defends herself and kills him. And she's arrested, of course, and she's charged. A lynch mob shows up, but the sheriff stops the lynch mob and allows a trial to proceed. And she goes to trial with an all-white male jury and is convicted and given the death penalty. And she's later hanged, but she had an all-white jury. And most of you know about the Scottsboro brothers, right? The Scottsboro Boys. 1930s trials, there were several different trials. And it's one of the trials where a lawyer decided to stand up and fight against this concept of all-white juries. And even though the Scottsboro boys went to trial multiple different times, they were ultimately convicted by all-white juries repeatedly, by all-white juries. And then here in LA, you all know Rodney King. I mean, I know Rodney King in Houston. Everybody in America knows about Rodney King. Even though the crime was committed on a video, The officers who were involved were acquitted by an all-white jury. When they went to trial the second time, the lawyers were dead set on trying to eliminate all of the blacks from the jury, so much so that the jurors were aware of it and made comments to the judge. And the judge still didn't remove those jurors because he believed they were right, that the lawyers were going over and above trying to get rid of the black people on the jury, and they were ultimately convicted in a case where they had 2 or 3 blacks on the jury. But previously, the very first trial that led to the riots in LA involved an all-white jury. And, you know, in America, our history of racism, one would think that it would tend to change, but there's not a whole lot of difference between 1964 and 2018. And, you know, we see it all the time. Every day we're on TV, we see policing, we see issues involving racism in America and the problems we have with racism in America. And I'll tell you this, people in America, because this slide I'm showing right now is a slide of Twitter activity that involves hate speech. Twitter activity that involves hate speech. Twitter tracks a lot of things, right? And one of the things that they track is hate speech. And so where you see the red areas, that's where you have intense hate speech that's occurring. The blue areas, the dark blue areas, is strong hate speech. And then the light blue areas are areas where you're seeing some hate speech that's happening on Twitter. So in America, this racism, this issue that we have with race and being racist is something that's endemic of most of our people, or a lot of our people. And prosecutors are people too.
To get a competent, fair, and impartial jury. Well, that's ridiculous. You're there to win. And in order to win, and the defense is there to win too, and the only way you're going to do your best is to get jurors that are as unfair and more likely to convict than anybody else in that room. Let's face it again. There's the blacks from the low-income areas are less likely to convict. And as a result, you don't want those people on your jury. And it may appear as if you're being racist or whatnot, but again, you're just being realistic. You're just trying to win the case. You don't want smart people, because smart people will analyze the hell out of your case. They have a higher standard. They hold you up to a higher standard. They hold the courts up to a higher standard because they're intelligent people. They take those words reasonable doubt and they actually try to think about it. And you don't want those people.
Prosecutors are people too, right? Now most prosecutors are smart enough now not to record themselves saying some of the things that he said. They're smart enough not to say that. But this is training that's happening and has been happening across America in most DA's office. My boss, and when I was preparing this presentation, the PD was telling me about a case, the PD in Houston was telling me about a case that he was handling in Alabama, and they were trying a writ, and he actually contacted some former prosecutors, and they came in and gave affidavits attesting to how the DA's office had a policy of eliminating blacks from the jury. It was a systematic policy. And prosecutors are doing it. The one thing we have to know is that just only one black person can make a huge difference. Only one black person makes a huge difference. Many of you may not be aware of the Duke University study that they did, where they studied cases that happened in Florida, and they said one black in the jury pool made a difference in the conviction rates of African Americans and the conviction rates of Caucasians. It eliminated the disparity, just having the presence of African Americans. So if having the presence of African Americans is that essential, and we know prosecutors know that it's essential, and we know that prosecutors are intentionally trying to discriminate, then we have to really look at the issue of race and voir dire if we want to do justice by our clients. And so I want to kind of talk to you a little bit about that, right? I want to spend some time talking to you about something that we've heard a lot about, and that's combating racism through Batson versus Kentucky. I want to spend some time talking to you about Batson and about how to make a Batson challenge and give you some practical tips about making a Batson challenge. And then I want to give you some approaches to dealing with race in voir dire, how to actually talk about a jury panel. Because that first case that we tried in 2009, we didn't voir dire on race because we didn't think race was an issue. We had a black man who was accused of killing another black man. So we had no notion that the prosecutor would see race as an issue. But apparently, prosecutors see race as an issue in every criminal case when a defendant is black or Latino. And so, Batson versus Kentucky, you all are familiar with the case. It's a case that came out from the Supreme Court in 1986. The judges that sat on that case, most of them are gone right now. I don't think there are any of them that are remaining right now. But one of the pivotal ones, who's Thurgood Marshall, authored an opinion, and his opinion I think was interesting because he suggested that we needed to get rid of peremptory challenges. Back in '86, he thought that it was so dangerous that we couldn't trust prosecutors with it. Think about that, right? You got a Supreme Court judge who hears and reviews cases all day. And this is later in his tenure. He had been on the bench for quite some time. And his opinion was that prosecutors couldn't be trusted with it. So if that's the case, I think we can't be surprised. One of the first things we got to do when thinking about a Batson challenge is that we can't be surprised. We've got to anticipate discrimination. We've got to anticipate that the prosecutor is going to discriminate against our clients. Many of us may be friends with some prosecutors, and we find that kind of hard to do, to anticipate that the person who is our friend, who smiles at us, who we engage in conversation with, is going to discriminate against our client. But they will, and they do. And so I think we got to also take a step back and know the history of the use of race in jury selection in your county. The history of use of race in jury selection in your county. In some counties in Alabama, there are almost never black people on a jury because they're almost always excluded, right? And I think once you do that scouting of your county and the scouting of your prosecutor, you've got to then take time to consider educating the judge about it. So can you imagine filing a pretrial motion and file a pretrial motion and say, Judge, the prosecutor in this case has a history of routinely striking African Americans from a jury. In 60% of the cases that he's handled, he's eliminated 100% of the African Americans. Can you imagine giving that kind of information to a judge prior to a trial? The judge, if you have to make a Batson challenge, will be more inclined to grant the Batson challenge if you've laid the foundation in the record. In the case recently, the Foster case, Foster versus Chapman, which is a U.S. Supreme Court case that was recent. It was the most recent case that they decided a Batson issue in. In that case, the lawyers filed a pretrial motion. And their pretrial motion was a pretrial Batson motion. And it was a motion that says, Your Honor, we move to prohibit the prosecution from discriminating against African-American jurors in this case. The prosecutor in this case has a history of discriminating against African-American jurors. They put the judge on notice that the prosecutor had a history of discriminating against African-American jurors. Now, he's in Alabama. So in Alabama, the judge didn't really care. He still went on and denied the Batson challenge, even though they had some pretty good arguments as to why it should be granted. It took the Supreme Court to overturn it, but if they hadn't have filed that motion and made the argument, then I think Chapman would have been killed, would have been executed, would have gotten the death penalty, right? So ultimately, I think we have to consider educating judges in regards to pretrial motions, and then prepare to preserve the issue for appeal. Now, making a Batson challenge. Now, I think the one thing that goes without saying is that you've got to take good notes during jury selection. Good notes during jury selection. And not just notes of like what questions are being asked, but you've got to track demographic information. You got to track different variables, and the questions that are being asked to jurors. Most of us in our jurisdictions, we have these little jury questionnaires. I usually use the jury questionnaires to chart a lot of information. And this is an example of one of the jury questionnaires I'll show in just a second. But we also want to be aware of the questions that prosecutors are asking to the group and paying close attention to the answers that are being given. So this might be what a jury questionnaire looks like when I'm filling it out. I'll take a look at it and start charting. If I've got an African-American man, I'm going to note he's an African-American man. I might also note his age. I might also note some information about where he lives, what part of town he lives in, and I'll do the same thing for every juror. And then I will pay attention to the answers that the questions the prosecution is asking. In particular, I'm going to listen for what they're asking, and I'm going to note them on my chart. I'm going to note, in my jurisdiction, prosecutors often ask jurors, what do you favor, punishment or rehabilitation in the criminal justice system? And somebody who says rehabilitation, they'll use that as an explanation for why they exercise their peremptory. So I will chart every time somebody says rehabilitation. And they'll also ask, what's law enforcement like in your community? You think it's good? You think it's poor? You think it's bad? They'll ask that kind of question too. And somebody says, I think law enforcement's poor. They'll use that as an explanation for exercising a peremptory. So I'll write them all down and chart all of these different things, these buzzwords that I know that prosecutors usually use to justify their peremptories. And I'll chart them all out and I'll keep track of what's going on because I'm listening closely. Usually in my office, we try cases with multiple lawyers. We'll have 2 or 3 lawyers trying cases. And the reason we do that is to do this in jury selection, is to really keep track of it, to really keep track of what's going on. Because once that happens, I think you can actually sit down and analyze the prosecution strikes. You can analyze the prosecution strikes. For example, let's say in this case you have one where the prosecution strikes all of the African Americans. We got 3 African Americans on the panel, and the prosecution strikes, all 3 are the African Americans, right? So if I'm taking good notes, I can sit down and analyze them, and I can look at it and says, I think there's an inference of discrimination created because there's some disparate treatment between numbers 5 and 2. Number 5 was rehab, and she thought law enforcement was good in her community, whereas number 2 was also rehab and thought law enforcement was good in the community. The only difference was race. So I can look at that. And I can look even further and say, I think an inference of discrimination is created between number 11, who's the African-American female, and multiple different jurors, 10, 9, and 4. They all answered the same questions. Law enforcement was good. And she's being struck. And then even further, I can look at it and says, they were the only ones that would ask questions about hardships, right? Anybody ever have a trial where the prosecutor comes out and he just starts asking questions to black people in the veneer? Anybody ever have a trial like that? Am I the only one? Okay, there's some other people. So they come out asking them questions and they're focusing on all of the black people. All that creates an inference of discrimination. It happens. It seems strange that they would try it, but that's done. If you try a lot of cases, you'll see that kind of thing happening. And so when you sit down and you get ready to make your Batson challenge, you've got to first state on the record that your client is a member of a protected group. You may approach, says, Your Honor, we're approaching, we object. Let the record reflect, Your Honor, that my client is an African-American, he's an African-American male. Or, Your Honor, let the record reflect, my client is a female, she's a woman. Or let the record reflect, Your Honor, my client is a Hispanic male in this case. And, so you want to state on the record that your client is a member of the protected group. If you don't state that on the record, you will not establish a prima facie case. Something just that simple. A judge will deny your Batson challenge and you won't have any action on appeal. And then, second, you want to point out that members of his race were removed and object to their removal. Point out, says, Your Honor, my client's an African-American male, let the record reflect that. And the state has struck jurors number 2, 5, and juror number 11. And we object to their removal because they're all African-Americans in this case, Your Honor. They're all African-Americans on the panel. And then you want to point out any aspect of voir dire that supports an inference of discrimination. I might say, Judge, the state has used their peremptories to eliminate all of the African Americans from the jury. They've eliminated 100% of the African Americans from the jury. And it may be an argument where we say they used them all and then come back, let's see, here we go. And we may say that they singled out black jurors for questioning. The Supreme Court has found that that's evidence to establish a prima facie case. And then we might ask that some jurors, not in this scenario I gave, but some jurors may not even be asked questions who are African Americans and it may be struck. And all of those things will be things that will establish a prima facie case. So once you establish a prima facie case of discrimination, the burden then shifts to the state. And so as the defender, you've got to scrutinize the state's explanations. You've got to scrutinize the state's explanation. So once the burden shifts, the state has an opportunity to offer a quote unquote race-neutral explanation as to why they exercise their strikes. And you've got to argue their reasons. They give the reasons, you ask, Your Honor, maybe I heard on those. May I be heard on those? Let's say in this situation, they come in and they say, well, Judge, we struck juror number 1 because, he had problems with the Fifth Amendment. He had some issues with the Fifth Amendment. He was kind of squirrely on his answer to the Fifth Amendment. And he was a rehab juror. and he thought law enforcement in his community was poor. You might come back and argue, say, well, Judge, there were several other jurors who also thought rehab was an issue. Other jurors who thought that law enforcement was poor in their community and the state didn't strike them. You might be able to argue that. You might lose on him because there's a lot of issues on that one. But if they came back and argued, well, Judge, our strike on number 5 was because she thought law enforcement was good. And you come back and say, well, there's disparate treatment. Number 5 and number 2 both gave the same answers. The only difference is race. And I think you do the same thing with each one of those jurors in trying to establish that their explanations are a pretext. All right? So let's say you go ahead and you make your objection. Your next step would be to take steps to preserve the issue for appeal. Now, by objecting, you generally preserve the issue for appeal. But a step you could take further would be to move or request that a copy of the prosecutor's notes or any charge that they use be made part of the record, right? Request that the prosecutor's notes or any charge that they use, copies of it, be made part of the record. Because on appeal, the courts may look to it and find information. You can even ask the judge, you can do an in-camera inspection. Ask the court to do an in-camera inspection. But you want to try to do what you can to get to the notes of the prosecutor. The recent case in the Supreme Court, the Chapman case, was overturned in part because of the prosecutor's notes. right? The lawyers had done an open records request later on after the fact and asked for the notes. And the Supreme Court accepted those notes and reviewed them. And there was a ton of discriminatory information inside the prosecutor's notes. They created a list of must-goes, jurors that must go, and all of them were African American. They created notes next to all of the black jurors' names that weren't present to some of the white jurors' names. So in terms of Batson, a way to preserve the record would be to ask for the prosecutor's notes. Okay, so in recap on Batson, don't be surprised, expect discrimination, because it's gonna happen in most cases. And then second, scout the prosecution. Know the prosecutor you're dealing with. Know the prosecutor's tendency or the prosecutor's predilection for striking African Americans. And then take detailed notes. And of course, think through making a Batson challenge before trial. Don't get to trial and be surprised when you have an all-white jury seated. Be ready before you get to trial. Think through the steps that you're gonna have to take in making a Batson challenge. And then of course, preserve any issues that you might have for appeal. All right, let's say you've done the Batson challenge. Now what about voir dire on race? How many lawyers here actually voir dire on race? A good bit of people, right? How many of you, when you have a black defendant who's accused of committing a crime and there's no cross-racial crime, how many of you still voir dire on race in those cases? All right, pretty good. I think in large part, most lawyers don't talk about race in voir dire. I think most lawyers don't talk about race in voir dire. You guys are kind of the exception. When I ask people about talking about race in voir dire, most lawyers don't. I was asked to try a case where my client, who was an African American, was accused of beating a white man to death with a crowbar. And a witness drives by and sees him striking a guy on the ground with a crowbar and calls in 911 and says, I see this guy, a black dude, beating somebody down. Look like he got a golf club or a crowbar, but he's beating somebody on the ground. He gotta be dead. And so we have this 911 call, and that witness comes in and he testifies as to what he says and so forth. But in any event, the client's charged with murder, with killing the guy. And so before trial, the client, I, and co-counsel, because we got the client out on bond, and we were sitting around talking. And I said, we got to talk about this, the elephant in the room. The elephant in the room is the ethnicity of the parties involved. And the client says, man, we're in Texas. We can't talk about race. We can't talk about race. We can't talk about it. We done had Cornell X. We done had Derek X. We done had all the X's out here, Ms. Davis. You talk about race, I'm done for. I'm done for. My co-counsel believed the same thing. He says, we can't talk about race. We can't talk about race. And I gave him examples about how we talk about race. And so I think that's the reason why most of us don't talk about race, a lot of lawyers don't, is that they're afraid of playing the race card. No matter how unfair the situation seems, no matter how obvious it is that race is an issue, we're afraid to talk about race because we're afraid of being seen as playing the race card. So I think it's important for us to talk about race. And I'm going to talk to you a little bit about talking about race. One of the ways I approach things, and one of the things that Mike didn't tell you, is that I'm actually on the staff of the Trial Lawyers College at Jerry Spence thing in Wyoming. I'm on the staff there, and I've been on the staff there since about 2005. And Jerry Spence and the Trial Lawyers College is a very unique way of doing voir dire. Part of what I'm going to tell you comes from that, part of it doesn't. Because I see a couple people who I know who went through the Trial Lawyers College and who are familiar with that method. And so some of what I'm going to tell you is stuff that I've developed over the years, but some of it is kind of from that. So it's a little bit different though. And so the way I approach voir dire, I never use somebody else's questions, so to say, at least not exactly. I might borrow from it, I might use a little bit of it, but I usually try to make it my own because it has to be true and I analyze it. So my development of questions starts with me examining my concerns about the case. What am I worried about the case? What causes me to lose sleep? What causes me some angst, some anxiety about the case? I'll start examining that. And then after examining it, I'll do sort of a personal assessment. I'll take inventory about how I feel about the different issues in the case. And then I'll kind of like apply the law and think about the law as it relates to those issues. And then I'll start getting prepared to share my concerns with different people about the feelings I might have, and what it might look like in voir dire on race. One of the issues I have, a concern I have, is if it's a cross-racial crime, I'm fearful that people might not be able to relate to my client. That people who are of a different ethnicity may not be able to relate to him, and they might side with the complaining witness based on a shared racial identity. I'm worried about that. That causes me concern. And I might have concern, if I'm going to talk about race, about being seen as playing the race card. And the fact that I even feel that I need to talk about race. We had a president, we were in this post-racial society, and I say that tongue in cheek. and we're at this stage, and yet I got to talk about race. I feel that way sometimes. And then my concern that people might presume my client guilty based on his race in any type of crime. Those are concerns and feelings that I might have, issues that I might be concerned with. And so, I say when you get ready to share stuff with the jury, you only use things that are true for you. If you aren't concerned with it, then don't do it. Don't get ready to try to talk to the jury about it if it isn't a concern for you, because the jury is going to see that it isn't, and you're going to seem like you're rehearsing things. You're going to seem like a phony. And voir dire is not the time to seem like a phony. It's a time where you want to develop trust. It's a time where you want to develop relationship with the people who are going to be deciding your client's fate. And so after I kind of narrow down my issues, I do a bunch of multiple mini voir dires. I talk to people. I'll see the postman who will come up and say, hey, what's going on, Mr. Postman? My postman's name is Rod. I may say, hey, what's going on, Rod? How you doing? And he'll say, hey, Mr. Davis, what's happening with you? I said, man, I'm just working and stuff. He said, what you got going on? I said, well, man, I'm dealing with this case. I got this young brother who's accused of raping a white woman. And he might tell me, he in trouble, Mr. Davis. He in trouble. That's here in Texas? I said, yeah, that's here in Texas, bro. He in trouble, Mr. Davis. Ooh, what you gonna do? What you gonna do? I said, you think that makes a difference? The fact that it's a black man who's accused of raping a white woman? He said, yeah. Anybody think it make a difference? Anybody think it make a difference? And so we might have a conversation, and that conversation is a mini voir dire, because I'm learning issues that I need to talk about. I'm learning how to talk about them, right? And I might even go to school, or I might drop my son off at violin lessons, and his violin teacher, who's a white woman, and I might say, hey, how you doing, Miss Rachel? She said, hey, Mr. Davis, how you doing? I said, I'm doing pretty good. She said, how's work been treating you? Oh, it's been treating me good. I'm dealing with this case, and it's kind of sensitive and everything. She said, oh, what kind of case is it? I said, I got this young black man who's accused of raping a white woman. And she might say, ooh, wow, ooh, how do you feel about representing him? And we'll start having this conversation. And the conversation is a mini voir dire. It's a mini voir dire because I'm getting an opportunity to talk to somebody who sees things differently than I do, who's not a lawyer, and who gives me some ideas. And so I might take those ideas and start formulating questions and refining questions through those conversations. We have a bunch of them, and I start thinking through the conversations, how I'm going to approach it, how I'm going to talk to it, and I'll pull together. And I say consider doing it. I think you need to do it if you can, if you have the resources. Not everybody has the resources. I recognize that. But if you work in a defender's office, you can pull some people together, some secretaries, investigators, others, and roll them as a jury and do a mock voir dire where you're working through questions that you might have, and you start asking different questions, and you might start formulating questions. I did this recently in a case that I have to try coming up. And I'm worried because the prosecutor who I want to try the case against just recently got a conviction in a case that the first time it was tried, the jury was hung 10-2 in favor of not guilty. The second time it was tried, the jury was hung 11-1 in favor of not guilty. But our DA persisted, and the third time it was tried, the defendant was convicted, and the jury was out less than an hour. And that was an all-white jury. The first two juries were juries with minorities on it, diverse jurors. But this last jury was an all-white jury. And so the case I'm trying with him is the third time the case is going to be tried, hung juries, etc. And so I know if he had that experience in that case, he's bringing it to my case. And we've got to try it in about 2 weeks. On the 25th is when we're picking the jury. So I've been thinking through voir dire issues and thinking through voir dire for that particular case. And so an example of voir dire, like I said, the method I use generally is a method of self-disclosure. I usually self-disclose, and it might look like this. Ladies and gentlemen, I don't really feel comfortable talking about this. It's something that I think I have to talk about. I don't feel good about talking about it. I need to talk about it. And I realized that I need to talk about it because I was working a case, in a rural part of Houston, in a rural area near Houston. And it's an area that was known for the skinheads. It's an area that was known for white supremacist organizations. And I'll be real with you, I oftentimes drive my car with it on E, and I play it close a lot of times. And I was there, and my car ran out of gas in that area. And so I closed up my car, and because I was in a rural area, I was wearing jeans and a t-shirt, I started to walk. And I was a little nervous walking, but I started to walk. And as I was walking, a truck with some dirt on it, some big wheels, riding real high, pulled up past me on the road and started to slow down. And I'll tell you, my heart started beating fast when that truck started to slow down. And as I walked closer to the truck, the window rolled down, and an older white man looked out the window and said, "Son, You look like you need some help. And we talked a little bit through the window, and then I got in the truck with him, and he drove me to a gas station to let me buy gas. And as he was taking me back to my car from the gas station, he told me, he says, you know, son, when I saw you out there, I thought you were up to no good. I saw you in this area, in this neighborhood, and I thought you were up to no good. And I told him, and I said, you know, sir, I'll be honest with you, I thought you were up to no good too. And I was really worried. I was really concerned when you slowed down. And he said something to me that was mind-blowing. He says, you know, and I'm running out of time. I'm going to end on this note. He says, he told me, you know, I think it's amazing how we see each other, how we view each other differently, how we make assumptions about each other. And I think that's true. I think we make assumptions about each other. Is there anybody here that kind of feels the same way? And that might be how I might introduce voir dire. So I'm out of time right now, but I will say this, there's in the paper that I've given you, I've included with it several different types of voir dire that you can do, several different examples of voir dire that you can do, and voir diring on race. And I want to leave you with something to know that voir dire on race is important. The case involving Curtis Flowers, he's the only African-American, only person in history to be subject to murder trials for the same crime at least 6 times. And they've all involved jury selections that eliminated all the African-Americans. So all of his cases have been reversed. He's trying them, been reversed, going back and forth because the prosecution has struck all black people. So it's something that still happened, and we have to be on guard. We have to be on guard. Yes. I have 20 more minutes? He was flashing the lights. It was an accident? Okay. All right, well, let me go back. I'm sorry. Well, all right, Mike, thank you. So I'll spend a little time just talking about some examples of voir dire on race and everything. So that's kind of the way I would voir dire on race, using the method I use of self-disclosure. I take an issue from my life, an experience that I've had, and use that experience to explain bias, right? Use that experience to explain bias. Another method that I think is really effective came to me from a lawyer in our office who does all mental health cases. I mean, all she does is mental health cases, and we were sitting around talking about the issue. And her way of voir diring on race, I love, because it's not as confrontational. Some people don't feel comfortable telling a lot about themselves. And she merely would start voir dire like this. Ladies and gentlemen, you've all heard the phrase that the defendant is entitled to a jury of his peers. And my client, in this case, is entitled to a jury of his peers. What might that look like? What do you think a jury of his peers might look like? And then she'll call for a show of hands and may get some answers, get a few answers. Let's say we have a jury panel here. My client's entitled to a jury of his peers. What do you think a jury of his peers? What do you think a jury of his peers might look like? Anybody? You think of somebody the same age as the defendant? Okay. So do you think a jury of all 80-year-old people would be a jury of his peers? What do you think? Do you think a jury of all police officers, if we had all police officers on a jury of all police officers, would that be a jury of his peers? Would he be entitled to that jury, or would he be entitled to more? What do you think about a jury of all women? What about a jury of all white people? And then she sort of went back into discussing the issue of race using that method. And then again, a role reversal. Imagine you were traveling to New York, right? And you went to New York, and this was a method that was given by a gentleman from Topeka, Kansas, a lawyer by the name of Johnson, who's been at NACDL, and I think there's even a video of him giving this example of voir diring on race. And so I want to credit him, because this is his method of voir dire that I'm describing, that I think sounds very effective. I'm going to plan to utilize it in the future, or a variation of it in the future. But let's say you were traveling in New York, and you and your wife were having a good time in New York, and you asked your concierge to say, hey, where's a good place we can go and get some jazz? Here's some jazz. And the concierge says, you know, you ought to go to Harlem. There's a place right on 5th Street in Harlem. And so you've never been to Harlem, but you think it might be cool to go someplace different and to hear some good jazz. So you go there, and you're having a good time. You're having a really good time. You're enjoying yourself so much that you get in a fight with somebody there, and you end up being arrested, and you end up getting hauled off to jail. And so when you go to court the next morning, you show up and they assign you a lawyer who's black. And you walk into a courtroom, and when you get into the courtroom, you look around, and the judge is black, and the prosecutor is black, and the bailiffs are black as well. And then you get ready to go to trial, and they bring in a bunch of people, and all of the people they bring in to be your jurors are all black. Do you feel you'll get a fair trial in that situation? Who here feels or has some concern about whether or not they get a fair trial? Now, thank you, man. Thank you. So Johnson tried cases in Topeka. Now, this is what he did. He'd have African-American defendants, and he tried cases in Topeka where he had all white jurors. He had white panels that would come in, no African-Americans on a panel. So he used that to sort of insulate the jury and prepare them for the fact that there'll be an all-white jury that will decide the fate of a defendant, that'll decide the fate of the defendant. And I love that method. And then, of course, there's a Tyrone Moncrief method. Anybody here familiar with Tyrone Moncrief? I know there are a couple people who probably are, right? Tyrone Moncrief is a lawyer who has lectured a lot for NACDL, and he tries a lot of cases in Texas. I mean, a lot of cases. Tyrone probably tries 20 cases a year. And most of the cases he tries are first degrees or very serious felony cases. And he's been practicing maybe 40 years or so. And he is a phenomenal lawyer. I've watched him try cases, and he's one of the best trial lawyers I've seen, no seconds. And one of the things Tyrone does in voir dire is, and I call it the Tyrone Moncrief method because it's unique. I've never heard anybody else do it. He says, ladies and gentlemen, when I first started practicing criminal defense, a prosecutor told me something I would never forget. He said that he's been trained in his office to eliminate all of the black people from the jury. And then if he had to, he'd leave one black person on the jury because he knew that the other whites would bully that one black person into making a decision they wanted him to make. And he did that because he knew that they were not familiar with his life and could not relate to his worldview or his life and his circumstances. He'd start his voir dire like that. And then he said, now, ladies and gentlemen, if I could have a show of hands, everybody who's African-American in the panel, can you raise your hands? So we see that there's only 7. There's only 7 African-Americans here in the panel. Now, it's very likely that we may have an all-white jury, or we may have one black person on the jury. Ma'am, if you're on a jury and you feel the defendant is not guilty, ma'am, will you hold to your guns? Will you be swayed by that? Ma'am, is the prosecutor right in assuming that race is an issue in the case? He'd do that in voir dire. Which I thought was totally unique, right? Totally unique way, but a good way of talking about race in voir dire. And then, of course, scaled questions. Scaled questions. In the paper, I think I include maybe 1 or 2 other ways to talk about race in voir dire, and you can look at the paper and see it. I give a detailed kind of like summary of it. But scaled questions. Anybody use scaled questions in voir dire? All right. If you don't use scale questions, what scale questions are basically questions where you ask the jury to sort of answer a range of questions. You might start off with a question like, what do you fear most? The question I use in every trial. What do you fear most? The guilty going free or the innocent being convicted? And if you fear the guilty going free, I want you to say guilty. But if you fear the innocent being convicted, I want you to say not guilty. And so I'll go to every jury, every panel member and ask them that question and have them all answer. So I get an answer for everybody on the panel and have them say, and I want to hear them say not guilty is the reason why I do it. But it also helps me find those people who are guilties, right? Who aren't afraid of an innocent person being convicted, which is like incredible. And in Texas, you'd be amazed at how many people there are. Who are on a given panel. So like in race, with the race as an issue, you might be able to fasten scale questions because it's a little easier for people to answer, right? Some people who might not necessarily answer a direct question about, oh, you're a racist, might answer a question that gives you an indication that they are a racist, right? So you may ask a question something like this. I want you all to answer the following question, picking between these 3 questions. And I want you to answer true, partly true, or false, and here are the questions. Now, racism by whites against, Hispanics is a thing of the past. Is that true? Partly true or false? And then to each juror or each veneer person, you'd ask the question individually. You'd have them answer and have them all go say true, false, etc. And people in that kind of context will be more likely to tell you how they feel. And then you can fashion all kinds of questions that way. You can say, black people commit more crimes than whites. True? Partly true or false. And you can go through the panel and see where people's predilections are. If somebody comes in and says, you're looking like, nobody gonna answer that. Believe me, people will answer that. They will tell you that it is true that blacks commit more crimes than whites, right? If somebody tells you that you got a black man on the jury, do you want that person on the jury? No, this is something that you can use to even get to a cause challenge if you're skillful enough. Because one of the things you can do, you can ask them, so you say, now, we had a couple of people who said true to this question. You said that you thought African Americans commit crimes at a greater rate than whites. And I saw the hands and I noted the hands. And you can ask them, says, now, ma'am, would you say that you could start the defendant off, right? Now, you're kind of starting with an idea that you have. And I understand that idea. And that's fine to have that idea. It's your idea. But you're starting with that idea. You're kind of starting him a little bit behind, right? We're kind of presuming that he may be guilty. You see how you can go with that to get a cause challenge? You can go and ask and says, well, can you presume him innocent? If you think he's going to commit crimes more, is this something that you may not be able to presume him innocent on because he may have a predilection to commit crimes? You can use that to get to it. Any question you can think of, you can kind of fit into a scale question. At the least, it gives you some insights into how you should exercise your peremptories. At the least. All right. And are blacks more do blacks use more illegal drugs than whites? True, partly true, or false? Any question you can put into it. And then I wanted to leave you with that story of Curtis Flowers, who's that person who was charged. So, are any questions? Any questions? Yes, ma'am. I don't think people would admit to being racist, but people may admit to having some racist views. You follow me? So I think it's very unlikely. So the reason why I do self-disclosure, and I'm just going to be 100 with you, the reason why I do self-disclosure is because I want to tell people that I have these views, and that it's okay to express that you have these views. You get what I'm saying? So I'll come in and say, I felt that way. And I might tell the jury, I felt bad about it because I assumed this man was a pastor of a church, and he's giving me a ride to get gas in a car. And I believed that he was a skinhead racist. My feeling didn't stop when he rolled the window down. When I looked at him, I still felt that I was in danger, and some people might say, have anybody felt the same way? And people will tell you, yeah, they feel the same way. Most people, what I find is that most people acknowledge it if it's presented that way. Good question, though. Yes, sir. Thank you for sharing that, brother. Thank you for sharing. What's interesting? He said something. The Supreme Court of Mississippi said that the Curtis Flowers case was the worst case of discrimination it had ever seen. That's mind-blowing, right? I thought it was kind of mind-blowing too. So the Supreme Court of Mississippi says that. So that case has to be one. And one of the things that I've included in the paperwork is, and it's kind of long, but I included a copy of the brief that was filed in the Chapman versus Foster case. In that brief, you can kind of look at some of the arguments and some of the stuff that's attached. It's very helpful in terms of a resource. And you could also look at different Supreme Court briefs like the one in the Curtis Flowers case as well. So thank you for sharing that. Yes, ma'am? When a judge shuts you down, make your record. That's the first thing, of course. Anytime you're shut down on voir dire, you make your record. In my county, for example, one of the things that you've got to do, at least in my state, to preserve the record when you're being denied voir dire is to approach and read your questions into the record. Most of the time, every time I've done that, every time when I've been shut down on voir dire and I've approached and I started reading my questions in the record and I started laying the record, I've been allowed to voir dire on the topic. I've been allowed to voir dire on the topic. And but to answer your question directly, I think there are a couple of different things you can do. Of course, first, make a record. Second is prepare ahead of time. Most of the time as PDs, we have good information, intel on most of the courts. We know the judges that are going to shut us down on different issues in voir dire, right? So in those cases, we can ask for jury questionnaires. Something you can do, and race is a good topic to ask for a jury questionnaire. Most judges will go with a jury questionnaire if they think it's going to shorten voir dire. You can say, Judge, in your argument, say, Your Honor, I think, instead of us doing an hour of voir dire, this might shorten our voir dire to 45 minutes if we had the jury look to a jury questionnaire. Or instead of doing 2 hours of voir dire, it might shorten our time frame to 45 minutes of voir dire, whatever argument you need to make to convince the judge, because they're really concerned more so about time, right? And then secondly, you can kind of preface it to the judge. There was a judge that I did not like in Houston who I thought was a prosecutor in the black robe. But he did something that was very helpful in all of his trials. He'd ask you, do you have any tough issues you need voir dire on? And if you told him ahead of time and you kind of suggested how you wanted to voir dire on, he would follow it to a T and voir dire on the questions that you wanted to ask, because it was his belief that he could kind of at least preserve or save some of the jurors. You get what I'm saying? So I think you got to kind of use that. If you got a judge, use those kind of different methods to try to get to it. Yes, ma'am. I think you got to inoculate. Anytime you're trying to keep a challenge for cause active, you got to inoculate the jury. It says, hey, look, ma'am, thank you. Let's say, for example, I ask you, so ma'am, you don't think you could be fair and impartial in this case, right? Say no. Thank you, man, for saying that. Now, the way we feel is how we feel. Our life experiences can't change. Nobody can change your life experiences in 2 minutes or an hour or 2 hours, no matter how long we sat and we talked to you. The judge might tell you or come and ask you, says, you know you can be fair. You know you can be fair. But if in your heart of hearts you feel you can't be fair, it's all right for you to say that. It's all right for you to hold to that. Don't let anybody change that, because once you get in the jury room, you're not going to be able to change that. I think you do that with maybe like 1 or 2 jurors, the rest of the panel is going to hear that. And they'll know that they can hold to their guns. All right. Yes, ma'am. I'm hopeful that there is. I know, and she was talking about the state of Washington doesn't like to think that they're racist, but the state of Washington is ahead of everybody else. I mean, they've got a judicial order. It's not a legislative fix, but their Supreme Court, I think, passed a rule that limits discrimination in Batson. I think it would be great if there was a legislative fix. If somebody could lobby Congress and maybe have them pass one. It'll take time to fashion something. But I think if there was something that limited or restricted the use of peremptory challenges for purposes of race, it would be helpful. Yes. Yes, sir? So now this might require you, I don't know if you have any interns. Do you have any interns at your office? If you have interns in your office, it might be a good project for interns, because it can be kind of time intensive. One of the things that you can do, obviously, is you can go down and request, like for example, if you've got one prosecutor who's tried cases, you can request the names, a list of every trial the prosecutor's done. And then you could go through every one of those trials and find that information. You follow me? So if you got a situation where you got a prosecutor who's been involved in 30 trials, you can go down to the courthouse and look at all of the trials he's done. You can even look at the jury compositions. They keep all of that information. In my venue, in my county, they keep all of that information. You got to go down and pull that. In yours, they probably do too. I'd be surprised they didn't. I really would be. The reason why I say that is because oftentimes on appeals for writs of habeas corpus, 10, 15 years later, that information is there. And nearly most venues and places where they have motive to destroy it, it's still there. So if you're on the West Coast, are you out here in California? Where are you? In New York? So I don't know about New York. What's that? New York City? So I don't know about New York City, New York, but probably, I'd be surprised if it wasn't present in New York too. So that's something you'd have to do. Another way you could do it is to keep track of the prosecutor. Start scouting the prosecutors. Find out people who go on to trial with him, right? The case I told you about the prosecutor who I got a trial with, I know that because I talked to the lawyers who tried the case. I asked them, so what happened with the jurors? They told me, said, man, first time we had this, second time we had that, and the third time, so I know that from talking to them, and kind of going through it. So scout them out. When I say scout them, I mean talk, find out, get intel on them, find out what's going on. Any other questions? Yes, ma'am. So her question was that oftentimes jurors of color are very candid about their feelings about the police and their feelings about race. They'd be talking, and of course they'd alert the prosecutor to them and end up getting struck. And so she's asking, so how can you, any way you have any tips on how to keep them from being identified? Now, the way I usually ask questions is that, I don't want to say this the wrong way, so I'm just going to say it the best I can. I believe that lawyers think they're better than they are in voir dire, right? Because I think people come to voir dire or come to a jury selection situation, and for the most part, people are who they are. You're not going to change somebody's worldview in the hour that you have for voir dire. So my view isn't to try to stand up and give speeches in voir dire and try to figure out how a person, if I can change this person's mind to my view on things. My approach on voir dire is to find out who the people are that are going to hurt my client and to strike them. So usually when I'm doing voir dire, it seems like it's going terrible. Ooh, that's a terrible voir dire. Because you have people talking about all of this crazy stuff. But that's, for me, that's great. That's a great voir dire because I want them to talk about all this stuff so I can know who they are and get rid of them and get them off the panel. So in answer to your question, a way of insulating some African Americans is not talk about those issues. For example, is there anybody here who's been falsely accused of a crime? Anybody been falsely accused of a crime? Should never be a question that you should ask on voir dire. Never, because you want those people to sneak into the back door. You want to get those people on your panel, right? I've seen lawyers talk about that on voir dire, and I think it's a terrible question because you don't want to know who those people are, because as soon as you know about them, the prosecutor knows about them too, and they're not making it on the panel. So my question is anybody here who's ever been a victim of a crime and nobody listened, right? Isn't that a great question? Because you'll find somebody who wants to come in and get their justice through your client and on your client's back. So I'll ask those types of questions, and I'll avoid the questions that'll make African-American jurors talk. I'm asking questions about who's racist, not who's been the victim of racism. I don't want to know that. I want to know the people who may have racist predilections. I think I might be done now. All right, and one, was that? One more. I was going to say I would be in the back to answer questions, but yes, sir? Thank you for raising that. His question, his comment was that all black jurors are not good jurors, and that is true. You have some black jurors who be hard on your client than the white jurors would be. That's absolutely true. Prosecutors don't seem to get that, but that is true. So oftentimes we want to know who those people are. Those people usually let themselves be known. You know what I'm saying? They'll usually let themselves be known. Sometimes so much so you like, man, come on, we already got you. Right? So, but thank you all for your time. If anybody has any other questions, I'll be in the back.